So, a federal judge just delivered what legal experts are calling the most devastating courtroom takedown of Donald Trump's immunity defense in modern history, and the moment it happened, you could literally see Trump's legal team realize their entire strategy had just collapsed in real time. And what triggered this judicial evisceration? Trump's attorneys made the fatal mistake of arguing that a president could theoretically order the assassination of a political rival and still claim absolute immunity from prosecution. The judge didn't just reject this argument, she systematically destroyed it with a level of legal precision that left Trump's lawyers visibly shaken and scrambling to salvage what remained of their position. It's honestly hard to believe we watched this unfold. This isn't just about one bad day in court or a routine legal setback. We're talking about a federal judge essentially declaring that Trump's entire legal theory, the foundation of his defense strategy across multiple cases, is constitutionally absurd and dangerous to democracy itself. And trust me, the implications of this ruling extend far beyond this single courtroom. This decision could reshape every pending case against Trump and establish precedent that no former president can hide behind immunity claims for criminal conduct. Let me fill you in on what's been happening. Trump has been facing multiple criminal indictments across different jurisdictions, from the federal documents case to the January 6th related charges to state-level prosecutions. From the beginning, his legal strategy has been consistent. Claim absolute presidential immunity for any actions taken while in office, argue that prosecuting a former president sets a dangerous precedent, and delay proceedings as long as possible while these immunity claims work through the courts. His attorneys have argued repeatedly that a president must have broad immunity to function effectively, that the threat of prosecution would chill executive decision-making, and that political opponents could weaponize the justice system against former presidents. This strategy worked for months, successfully delaying trials and creating legal uncertainty about whether Trump could even be prosecuted. According to Politico's December 18th report, the immunity hearing that just concluded was considered the most critical legal moment in Trump's defense strategy. If the judge ruled in his favor on immunity, multiple prosecutions could effectively collapse. If she ruled against him, Trump would face trial without his primary shield. But here's where the rubber meets the road. During oral arguments, the judge pressed Trump's attorney on the outer limits of presidential immunity. She asked a hypothetical question that's become standard in these hearings. If a president ordered SEAL Team 6 to assassinate a political rival, could that president be prosecuted? Trump's attorney, instead of clearly stating that murder is obviously not covered by immunity, gave an answer that stunned the courtroom. And before we go any further, let's be real for a second. When your legal strategy requires you to argue that presidential assassination orders might be protected conduct, you've already lost the moral argument. The question is whether you're about to lose the legal one too. Here's where it gets interesting. According to multiple reporters inside the courtroom, including from CBS News and CNN, Trump's attorney initially tried to dodge the question, saying it was an unrealistic hypothetical. But the judge wasn't having it. She insisted on a direct answer, making clear this was central to understanding the scope of immunity Trump was claiming. The attorney, backed into a corner, essentially argued that even ordering an assassination would require impeachment and conviction by Congress before any criminal prosecution could proceed. He claimed that without that political process, absolute immunity would shield even that conduct. The courtroom atmosphere changed immediately. According to reporters present, several people in the gallery audibly gasped. The judge sat back in her chair and for a long moment said nothing. Then she leaned forward and began what witnesses described as a methodical dismantling of the argument. She pointed out that the attorney's position meant a president could commit the most heinous crimes imaginable, leave office, and never face justice if their political party controlled enough Senate votes to prevent conviction. She noted this would place presidents above the law in a way the founders explicitly rejected when creating our constitutional system. The bombshell came when the judge stated for the record that she found this interpretation of presidential power not just wrong but dangerous. She said, and I'm paraphrasing the accounts from multiple reporters, that accepting this argument would fundamentally transform the presidency into a position with monarchical powers that no court should recognize. She made clear she was rejecting the immunity claim in its entirety. Trump's attorney immediately tried to walk back the assassination hypothetical, claiming he'd been misunderstood, but the judge cut him off. She said, His answer had been clear, and that it revealed the logical conclusion of Trump's immunity theory, a conclusion she found constitutionally indefensible. This testimony sent shockwaves through the legal community because it represents a complete rejection of Trump's core defense strategy. Every case where he's claimed immunity now faces a precedent from a federal judge who explicitly called the theory dangerous. The careful legal positioning that Trump's team has maintained for months collapsed in the span of one disastrous exchange. Now, this isn't the first time we've seen Trump's legal strategies crumble under scrutiny. Just think about how his election fraud claims played out in court versus how they were presented in the media. For weeks after the 2020 election, Trump and his attorneys held press conferences making sweeping claims about massive fraud, rigged voting machines, and stolen elections. But when those same attorneys got into courtrooms and faced judges demanding evidence, the claims evaporated. In case after case, Trump's lawyers admitted they had no evidence of fraud, withdrew allegations, or made arguments so weak that judges, including Trump-appointed judges, dismissed them with prejudice. The gap between the public rhetoric and what could actually be proven in court was enormous. Then there was the whole executive privilege fight over January 6 documents. Trump claimed sweeping executive privilege that would block Congress and investigators from accessing White House records. He argued this privilege was absolute and extended indefinitely after leaving office. Multiple courts, including appeals courts, rejected this argument entirely. They found that former presidents have limited privilege claims, that congressional investigative authority is broad, and that Trump's interpretation would essentially allow presidents to hide evidence of wrongdoing permanently. Trump lost every major ruling in that fight. And let's not forget the Mar-a-Lago documents case, where Trump's attorneys initially claimed he had declassified everything telepathically, then argued the Presidential Records Act gave him unlimited authority to keep documents, then claimed attorney-client privilege over materials, then argued executive privilege. Each theory was more desperate than the last, and each was rejected by courts as lacking legal foundation. The special master Trump's team requested ended up becoming a disaster for them when he demanded they actually prove their claims about declassification, something they couldn't do. Even his defamation cases have followed this pattern. Trump claims things publicly with absolute confidence. His attorneys try to defend those claims in court, and judges systematically dismantle the legal arguments. The E. Jean Carroll case resulted in massive damages after Trump's defense strategy failed completely. His appeals claiming judicial bias were rejected. His attempts to avoid giving testimony failed. Now, it looks like presidential immunity joins this long list of legal theories that sound compelling in press conferences but collapse under judicial scrutiny. The pattern is unmistakable. Trump's legal strategies rely on making sweeping claims about presidential power and hoping courts will defer to executive authority. But when judges actually examine the constitutional basis for these claims, they find nothing there. So what specifically did the judge say that caused such a dramatic reaction in the courtroom? Let's break it down. According to reporters from multiple outlets who reviewed the transcript, the judge's ruling addressed three key aspects of Trump's immunity claim. First, she rejected the notion that presidents have absolute immunity for any actions taken while in office. She cited Nixon versus Fitzgerald, the key Supreme Court case on presidential immunity, and explained it grants immunity only for civil suits related to official duties, not criminal prosecution. She noted that accepting absolute criminal immunity would contradict the fundamental principle that no one is above the law. Now, here's the kicker. The judge went further, addressing whether Trump's alleged conduct, even if considered official acts, would qualify for any immunity protection. She stated that criminal acts undertaken for personal political benefit, such as attempting to overturn election results or retaining classified documents for personal purposes, are not official presidential duties. Therefore, even under the most generous reading of presidential immunity, such acts would not be protected. She essentially ruled that Trump can't claim he was acting as president when he was actually acting as a candidate or private citizen. The judge then addressed the parade of horribles argument that Trump's attorneys made, their claim that allowing prosecution of former presidents would lead to politically motivated charges against every president. She acknowledged this concern, but noted that we have multiple safeguards against politically motivated prosecutions, including grand jury requirements, prosecutorial discretion norms, and the factual specificity required for indictments. She stated that fear of potential future abuse cannot justify granting current presidents immunity from prosecution for actual crimes. According to MSNBC's legal analyst who was in the courtroom, this section of the ruling was particularly devastating because it showed the judge had anticipated every argument Trump's team might make on appeal and had already addressed them comprehensively. This leaves Trump's legal team in an extraordinarily difficult position. On one side, they need to appeal this ruling immediately because it threatens Trump's defense strategy across multiple cases. Every jurisdiction where he's claimed immunity can now cite this detailed judicial rejection. That means accelerated timelines for trials that Trump has been trying to delay indefinitely. On the flip side, they have to appeal an opinion that makes their legal theory look not just wrong, but dangerous. The assassination hypothetical is now in the court record forever. Any appellate court reviewing this will read about Trump's attorney appearing to argue that presidential murder orders might be immune from prosecution. That's not the kind of precedent you want in the record when seeking appellate relief. The tricky part is there's no clean way out of this. So Trump's attorneys are caught in a bind. They can either double down on the absolute immunity argument, which means defending the logical implications that the trial judge found so troubling, that risks appellate courts being equally troubled and issuing even broader rejections of immunity claims, or they can try to narrow their immunity argument, claiming they never meant anything as extreme as the judge suggested, but that contradicts their own statements in court and makes them look like they're retreating from their position, which could encourage prosecutors in other cases to push harder. It's a disaster entirely of their own making. They took a maximalist position on presidential immunity, thinking courts would defer to executive power. Instead, they got a judge willing to examine the logical conclusions of their argument and finding those conclusions constitutionally unacceptable. Explaining it away requires admitting their legal theory was always flawed, but maintaining it means defending truly indefensible hypotheticals. This whole scenario is causing panic throughout Trump world. If absolute immunity is off the table, Trump faces trial on the actual evidence and facts of each case. There's no procedural shield protecting him anymore. Other defendants in related cases, like the January 6th.co conspirators or Documents.co defendants, are now wondering whether their own legal strategies need to change. And Republican officials who have been defending Trump by attacking the prosecutions as politically motivated now face judicial rulings that affirm the prosecutions are legally sound and constitutionally necessary. According to Fox News coverage, even reliably pro-Trump legal commentators struggled to defend the assassination hypothetical. Several focused on attacking the judge's bias rather than explaining why Trump's legal theory makes sense. When even conservative legal voices can't defend your position on the merits, you know it's bad. Meanwhile, the prosecution teams in multiple cases appeared energized. According to courtroom observers, prosecutors in this case were visibly pleased with the ruling and have already begun coordinating with other jurisdictions about how this precedent affects their cases. The immunity defense they've been fighting for months just collapsed completely. Things became even more intense when Trump himself posted on Truth Social shortly after the hearing ended. He called the judge corrupt, claimed the ruling proved the justice system was rigged against him, and insisted he had absolute immunity regardless of what any judge said. Legal experts immediately noted that attacking the judge handling your case while appeals are pending is extraordinarily ill-advised. It gives appellate courts no incentive to view your arguments sympathetically and could potentially be used as evidence of consciousness of guilt. Legal analysts are noting that rulings this definitive on presidential immunity often prove decisive. When a federal judge comprehensively rejects your entire legal theory and provides detailed reasoning, appellate courts frequently affirm those rulings. Andrew Weissman, former Mueller probe prosecutor, went on MSNBC and stated that this ruling likely dooms Trump's immunity claims across all his cases. He noted that the judge's reasoning was thorough, well-grounded in precedent, and directly addressed the policy arguments Trump's team made. He said appellate courts would be hard-pressed to find reversible error in such a carefully constructed opinion. Former federal prosecutor Eli Honig added on CNN that the assassination hypothetical would haunt Trump's appeals. He explained that once that exchange is in the record, every judge reviewing the case will read it and have the same reaction the trial judge did. You can't unring that bell. The hypothetical revealed the stakes of Trump's immunity claim in a way that makes granting immunity almost impossible for any judge to justify. Just think about that for a moment. A veteran prosecutor is saying this single exchange might be sufficient to doom immunity claims across multiple cases. And this is just one hearing in a legal battle that includes extensive evidence of alleged criminal conduct. So, let's break down what this ruling could mean, because it's not just a captivating legal drama. It has serious consequences for Trump, his legal exposure, and the future of presidential accountability. First up is the immediate trial impact. Multiple cases against Trump can now proceed without further immunity delays. The judge's ruling provides a roadmap that other courts can follow when rejecting similar immunity claims. Legal observers who have been following Trump's cases closely told Politico that this ruling fundamentally changes the timeline. Before today, Trump's legal team was successfully delaying trials potentially past the next election. After this ruling, several analysts described trials in 2025 as highly likely. The precedent this sets is significant. According to legal scholars, this is one of the most comprehensive judicial statements on presidential immunity in the criminal context we've ever had. If it stands on appeal, it establishes clearly that former presidents can be prosecuted criminally for conduct that violates the law, even if that conduct occurred while in office, as long as it wasn't part of core constitutional duties. That's a major clarification of constitutional law. Now, let's touch on what this means for Trump's broader legal situation. Without immunity as a shield, Trump's defenses in multiple cases become much weaker. He'll have to argue the actual facts, whether he really declassified documents, whether his actions on January 6th constitute criminal incitement, whether he falsified business records. Those are much harder cases to win than a blanket immunity claim that avoids the facts entirely. Prosecutors in other jurisdictions are undoubtedly watching this ruling carefully and preparing to cite it in their own cases. Looking ahead to the political implications, Republican candidates will now face questions about supporting someone whose own lawyers suggested presidents might have immunity for ordering assassinations. That's not a hypothetical that polls well. The ruling creates a concrete legal narrative that's far more damaging than abstract arguments about political persecution. Voters can understand that Trump claimed he was above the law and a federal judge said no, he's not. This isn't just about one ruling or one case. It's about whether we still have a constitutional system where presidents are subject to the rule of law. If Trump had won on immunity, we'd be in a world where presidents could potentially commit crimes with impunity as long as they maintained enough political support to avoid impeachment conviction. That's not a republic, it's an elected dictatorship. The judge's ruling reinforced that we're still a nation of laws, not men, and that applies even to presidents. The next few weeks are going to be crucial. Trump's attorneys have to decide whether to appeal immediately or try to narrow their claims. Either option has serious risks. Meanwhile, prosecutors in multiple cases are preparing to move forward with trials now that the immunity shield is gone. The timeline that looked favorable to Trump, delays extending potentially past the next election, has suddenly accelerated dramatically. So, here's the deal. Donald Trump's lawyers argued in federal court that presidents might have immunity even for ordering assassinations. A federal judge called this theory dangerous and constitutionally indefensible, and Trump's entire immunity defense strategy just collapsed in real time. This isn't just about Trump losing a legal argument. It's about whether our constitutional system still functions to hold powerful people accountable when they violate the law. When your legal theory requires defending presidential murder orders as potentially immune conduct, you've revealed that your theory was never about protecting legitimate executive functions. It was about placing one person above the law entirely. If this ruling stands, then we're watching the legal system function exactly as the founders intended, rejecting claims of monarchical power and affirming that presidents, like all citizens, must answer for criminal conduct. That would mean the pattern of Trump escaping accountability through legal delay and procedural arguments has finally hit a wall. It's about so much more than just Trump's legal troubles. It's about whether anyone, regardless of how much power they once held, remains subject to the same laws that govern everyone else. So, keep an eye on this. The appeals process begins immediately, with Trump's team expected to file emergency motions. But they're appealing a ruling that's thorough, well-reasoned, and addresses their strongest arguments. Other courts handling Trump cases are watching and likely to follow this precedent. And that assassination hypothetical is now permanently in the legal record, undermining Trump's immunity claims in every jurisdiction. The stakes have never been higher. the legal theory never more thoroughly rejected, and the path to trial never more clear.